So at our law firm, we talk regularly about loans because oftentimes there's a lot of inter-family loans that happens. Child is starting a business and mom and dad loan the child money. Maybe somebody's experiencing financial hardship and somebody gives them a loan. Inter-family loans are really tricky because people will sometimes say this is a loan, but they don't treat it like a loan. And what do I mean by that? So, if you are actually making a bona fide loan as opposed to a gift, there are certain requirements that you should heed. First, you have to charge an interest rate, and there is a minimum interest rate. It's called the AFR rate, and it's published monthly by the federal government. So you can just Google AFR rate and you can see what this month's federal required interest rate is. And they do it by short term, midterm, and long term. And so those are defined by how long the loan is, with the long term being greater than 9 years. So if you are loaning money, it should be in writing. And the person who is on the hook for paying it back needs to sign the promissory note. It needs to talk about what the interest is. It must charge interest at least at the AFR rate. And it needs to talk about at what frequency does that accrue, when are principal payments owed, does it balloon at any particular time, how long does the loan last. And something that also is important to consider is if you have a revocable trust and you're a parent and you're loaning your child money. If you die, they still owe you money. You should have the lender in this situation be your revocable trust. Otherwise, the payments back to you are going to be paid to you personally. And if you're dead, it's going to be payable to your estate and it can become a probate asset. So you don't want this triggering probate. Make the lender be your revocable trust. That's one thing to consider. Another thing to consider is if at your death it isn't paid back, do you want this loan forgiven? Or do you want this loan to reduce this child's share at your death? Because if it's not paid back at death, and let's say their share is 200 and they owe you 20 at death, instead of getting 200, they may opt to get 180 at your death. And they're taking a reduced amount because part of their 200 amount, they're basically throwing back in the pot and paying off their loan to you. Alternatively, some people will say, you know what, if it's not paid back by the time I die, I'm just going to forgive it and they're not going to owe me this money. So that's another way to do that. If that's what you want, you have to modify your will or trust to say, on such and such a date, I loaned Joey money. If it's not paid back by the time of my death, I want it forgiven. And then something that needs to be further considered when modifying your will or trust regarding that is if your child passes away before you do you want this cut down in their share? Do you want that to go to their children? So you gave them this money, they never paid you back, you forgave it during their lifetime. So are you going to reduce the grandchildren's share of that child, or are you just going to leave it be the same? So those are all things to consider. Now, if you don't want to make it be a loan, you don't want to charge interest, you don't want to collect payments, you don't want to treat it like a bona fide loan, it is a gift. And I have many videos on our YouTube channel that talks more about gifting and when you have to file a gift tax return. But if it is a gift, then there are different legal consequences to that. So that is something to know. You're giving large amounts of money to a family member. Are you treating it really as a loan or as a gift? And as a result, what do you have to do legally as a result? Thanks for listening today. If you want to learn more about estate planning, subscribe to our YouTube channel. We are releasing new videos all the time, and you will be notified when our next video hits the channel. Thank you.